have any new counsel? Okay, my understanding is nobody's requesting to do appearances since we have the same counsel, correct?
Correct, yes, Your Honor, Dan Boho.
Well, it's
Very helpful for the recorders
Sorry,
because sometimes people are cutting and going every day.
In light of that request, I will ask you all to please do appearances. Counsels for plaintiff.
Yes, good morning, Your Honor, good morning, everyone. Theodore Parker, Will Kemp, and Eric Pepperman on behalf of the plaintiffs. We also have almost all of our plaintiffs here. We have 4 out of 5. We have Ms. Hartshorn, Ms. Brody, Ms. Sosa, and Mr. Hunwardsen.
Thank you, and we understand that you also have an expert who's going to be testifying.
We do. We have
So
Ms.
not subject
We have
to
Dr.
dispute.
Catherine Hunt back there.
Okay, counsel for real water, go ahead, please.
Good morning, Your Honor. Joel Odou for Real Water. I have with us co-counsel Myles Water, Eric Freeman, and Matt Kaufman for the Real Water defendants.
Thank you, go
Good
ahead.
morning, Your Honor. Dan Boho on behalf of ETT1. With me is Valerie Rojas, Dan Wade, and Jan Tomasic. And Abe Smith is as well, sorry.
Good morning, Your Honor.
He was behind her, we didn't see.
Yeah, no worries, that's the thing, it's one advantage of this viewpoint, I can see some things that you all can't. Okay, so, I
I
understand there's a couple.
noticed that in the case generally, Your Honor.
Yeah, so, okay, thanks much. So, I understand there's a couple matters outside the presence of the jury. So, which one are we doing first? I understand, let me just finish up from yesterday's issue, right? And then we'll go to the new one. So, there was a confirming with regards to documents to ensure that they were properly redacted. Is that all taken care of, counsel for plaintiff, or is there anything else?
Your Honor, I've not spoken to Real Water about this. I had a quick conversation with Mr. Boho about it. I believe he said from his point of view, they're properly sanitized, Your Honor.
So, real water, do you have a chance to look at that?
Yes, Your Honor. Joel Odou for Real Water. We have no issue in this dispute, and did check and didn't see anything to the objection generally.
Okay, thank you. Counsel for ETT, you can concur?
Your Honor, I did take a brief look at it. I did not see anything in the look that I took.
Okay. So that's a non-issue, right? Nothing needed for the court at this time, is that correct?
Except I need to actually give you the copies.
Okay, yeah. I'm getting those because is it then by agreement of the parties? Let's find out. That's why first I have to make sure it's not an issue, right? The next step is there can be a stipulation. So I see both of you all standing. Who should I be asking?
I can handle this part of it, and
Okay.
Mr. Pepperman probably can handle more of the larger umbrella, but in terms of the exhibits that I'm speaking of, we wanted to simply substitute exhibits 369, 370,
Sorry, there's 369,
369,
370.
370. The next one, Your Honor, is 526, 371, 527, 528, 575, and 368.
Okay. So is it a correct understanding that those are all exhibits that were previously provided electronically at the appropriate time period? What you're now requesting is potentially to replace the electronic copies, instead utilize the hard copies because of the redactions that you need to make to those documents, or is it something different?
No, that's exactly right, Your Honor. We redacted the caption, and then one document had a reference to insurance that we caught.
Okay,
So that's it.
and so how many copies do you have of, say, documents for the clerk?
I can give the court whatever the court likes. I gave Real Water yesterday, I gave Terrible Herbst. I have a copy right here of all of those. Then I have one for myself, but the
And
court
so
needs
then
two.
sorry, go ahead, I didn't realize you were not finished, go ahead, please.
No, the court needs more than one, then I can give you my number.
About to check with my clerk to see what she needs. And it has been taken care of electronically as well, so whatever gets put up on the screen has also been properly addressed?
That's correct, Your Honor.
Okay?
Okay.
Yes, Your Honor. Thank you, Mr. Conlon.
No worries, okay. So is it an agreement for the parties to replace the current electronic exhibits for the exhibit numbers that Mr. Parker just referenced and replace them with the paper copies that now have the redactions that the parties have had an opportunity to look at?
Your Honor, Joel Odou for Real Water, that is agreeable. I just want to make sure we understand the process in case this comes up again. I understand. So I just want to make sure what's being given to the court. And then the second question I have is, I think the court, maybe I misunderstood, was asking whether these are admitted. These are not admitted.
No, that was gonna be the next question, actually.
Okay.
Right now I'm at replacement, okay?
Yes.
And so to address your first question, I'm going to confirm with the clerk. First, I have to see if it's agreeable to replace, and then I'm gonna check with her on the exact process so that you're all told the same message on the process.
Thank
okay?
you.
And then the third step would be to see if they're admitted or if they're proposed, okay?
Thank you.
No worries, so I'm on first step, go ahead.
Your Honor, Dan Boho, we have very strong objections to these, but for process, no. I have no problem with the process that you have suggested.
Okay, so.
The original that goes to
Okay.
the jury.
Usually more. Okay, so what the clerk has confirmed is subject to if somebody to supervise, or you have to realize things change at different levels that we find out about when we find out about it. So our current understanding, okay, is what we're going to explain to you, is that as long as there's one copy of these proposed exhibits, 369, 370, 526, 371, 527, 528, 575, and 368. Is that the exhaustive list?
575 is actually 525, Your Honor. Ms. Garvey caught that.
Oh, sorry, 525, not 575?
That's correct, Your Honor.
Okay. So other than, so 1, 2, 3, 4, 5, 6, 7, 8 proposed exhibits can be substituted in paper format with taking no position as to admissibility at this juncture, but as long as one copy is provided to the clerk and the agreed upon substitution, then that can be done. Does that meet the needs of counsel for plaintiff?
It does, Your Honor.
Does that meet the needs of counsel for real water?
It does, Your Honor, just to make sure, in case this comes up again, I want to understand that if there's a substitute exhibit by agreement of the parties, a paper copy to the court is acceptable rather than an electronic copy.
If it is something that has already properly been submitted in electronic form timely.
Gotcha, thank you, Your
Okay,
Honor.
does that make sense?
Yes,
It's a different process if you're talking document versus tangible item versus document. Video, for example, when I think it was 394, 294, the video, the still was shown. That's a different process because that's changing format as well as actual document, okay? And there's a numeric component of that. You can appreciate if any party were all of a sudden saying, guess what, we want to replace, I'm gonna take a random number, this is not a ceiling or a floor, say you wanted to replace 100 documents. You can appreciate that presents a different challenge. We're talking a reasonable number of documents, that there was an error to get fixed, so you have a clear record, then that's fine. We're talking all of a sudden wanting to change hundreds of documents, that presents a different complex issue. So I think those are the appropriate caveats. That makes sense?
yes,
Does
it
that
does.
meet your needs,
Thank you.
counsel for real water?
Yes, it
Okay.
does, thank you.
So, counsel for ETT, process only on substituting paper or electronic that's been represented to the court, that the parties have all agreed that these were just documents that should have had some redactions to it. Those redactions comply with Supreme Court Rule 3, the type of information that needs to be redacted pursuant to applicable case law, right? And so that's just a replacement, and it's realistically, it's less than 10 documents, and in format, it's less than a couple of inches of documents. Does that meet your needs, counsel for ETT1?
Dan Boho, yes.
Okay, so then Marshall, can you please get the package of said documents from counsel for plaintiff, and please provide it to said clerk. Thank you, Ms. Rappel. Okay, so, next, does that take care of the issues for plaintiff? Is that
Your Honor.
the Parker and the Peppermint issues? Mr. Peppermint, does that take care of where you were standing as well?
Yes, Your Honor.
Okay, thank you very much. Mr. Boho, you had something, and you handed the court a couple of documents, so is that a similar concept that you're replacing, or is this for some other purpose?
Your Honor, that is to provide you with a copy, as was done with witnesses. Here, a copy of the exhibits that we will be presenting to the witness.
Are these proposed or admitted? Just
They are,
FYI.
they were agreed by counsel. There was one objection left in the initial list. It was on relevance. I've talked to Teddy and to Joel, and they have no objection to. They're waiving or not making that objection.
Okay, the reason why the court's asking the question is the documents provided to this court that you just indicated, which by the way, thank you, not necessary. I know sometimes when you all are having issues with giving the court something I need the court to rule on, but since you did show them to the court,
The number at the bottom is the 40 number, that's Exhibit 40, Your Honor. It's got 3 pages, and then the second one is Exhibit 41.
okay, so these are from plaintiffs proposed grouping,
Yes.
and they're objecting to it?
No, they are not. I've checked, no, there's
Oh,
no
okay.
objection from either the plaintiff or Real Water.
You can appreciate, when I was looking at what appeared to be the potential number, and I was hearing that there was still an outstanding objection and potentially on the relevance, that's why I was trying to ascertain. Okay, so those are proposed, okay. The court takes no, so do those, are you asking the court to find out now if the parties are gonna say in open court that these are deemed admitted by agreement of the parties?
Yes.
Okay, so let me circle around and do that for everybody, okay? So this exhibit 40, which is a 3-page document, exhibit 40, proposed exhibit 41, excuse me, which I think you gave me inadvertently 2 copies, but it doesn't really matter. It's just 40 and 41, correct?
That's 40 and 41. There's 3 pages to 40, Your Honor. It has a sub 1, 2, 3,
Sure.
and then the second one is 41.
Yeah, no worries, you just nicely gave me
Oh,
2
thank you.
copies of 41, that's all they're saying. Okay,
Oh, okay.
no worries, and I think you may have, since one has 3-hole punch, it might be your copy, you might want it.
Yes,
Marcia, if you hand that back to council.
if that's 41, I believe I have a non-3-vote punch.
Yeah, no worries, no, you gave me a non-3-hole punch, you just gave me 2 copies, that's what I was saying.
Okay, thank you.
And when somebody gives me one 3-hole punch, it usually means it's inadvertently their copy. Happens all
Yes,
the time.
thank you.
Okay, so is there an agreement by the parties to have the clerk show as stipulated admitted exhibit 40 and 41? Are you taking them independently? I'll take them independently. Counsel for finance?
No objection.
Counsel for real water?
That's fine, Your Honor, we can admit it.
Okay, thank you. So Madam Clerk, we'll deem those admitted, so then when you have your examination, you need to utilize them, then they can go up where they need to go up, and you can deem them as exhibits. Okay, anything else from ETT 1?
Yes, Your Honor.
Go ahead, please.
With regard to the first set of documents that Mr. Parker provided with regard to the discovery issues, all of the introduction
I'm
of...
sorry, discovery issues, you need to enlighten what,
You asked about 2-3 minutes ago, Mr. Parker provided a set of exhibits that are involved in the discovery in the case.
okay, you have to realize, he handed them to the clerk, I just hadn't seen them yet, so the clerk just handed them to me, okay, go ahead, please.
Now, in relation to those, and any questioning with regard to alleged litigation misconduct or litigation inappropriate, any litigation
I'm gonna pause you for
conduct.
a quick second, because here's what I'm gonna need to ask, okay? Is, right now, I really was just doing the quick administrative stuff, right? And we gotta see the jury, so if you all need the court to address motion practice, because this is gonna come up with a witness, either on the stand or the very next witness, and you want me to address it now, the court's gonna be fine doing that, but I'm gonna have the marshal let the jury know that they don't need to be standing in line. Okay?
Yes, would you please, Your Honor? We
Okay.
do need to address it substantively.
Okay, thanks, Marshall, right, just we need to
Thank you.
multitask, no worries, okay. So, you're asking to address outside the presence of the jury objections to the documents that were substituted from a substantive standpoint, is that correct?
Yes, and the line of questioning as well. This attempts to introduce a false issue into the case that is neither the evidence in the case nor the law of the case. With regard to this case can only be decided on the evidence that's relevant to the causation of the injury. Here, alleged misconduct is not related to the 2019 damages sustained by this particular person. Litigation misconduct is not in the jurisdiction of the jury, that's in the jurisdiction of the court. The court has spent significant time on this issue and a lengthy hearing on this issue, and that's where this is housed. Any action taken with regard to any alleged conduct issues by the parties in relation to discovery is something that sits squarely with this court. This court's already ruled, and I have felt it because witness after witness comes by and I can't question them. That's just a fact, that's just meaning in the case. But this is not an issue to be relitigated in front of the jury. It is highly inflammatory, and it's inappropriate because it's putting information in front of them that is not the actual conduct in issue. Pretrial litigation is not a consideration of the jury. We had this issue very briefly in the opening. Plaintiff had a chronology that included actions by the court, and I had said, I believe this was in front of the court, I had said, I don't believe that anything that's the history of this case is appropriate for this court, for this jury to consider, but I think that was just withdrawn. I don't think we ended up with an actual ruling on that. The document was not put in by the plaintiff. It had actions taken by the court.
Can I
So-
pause you for one quick second?
Please.
Are you saying the court didn't rule on something that it was supposed to rule on?
No, I believe that, I'm searching my memory. I believe that we started to discuss it, and I believe Mr. Parker said, I'm just gonna withdraw this. I think, so I'd have to look at the record on this. I just know we had discussed it, and I remember the court being involved in the discussion, but I think it was withdrawn from the request to the court to make a ruling by actions of counsel. In other words, I think he just took it. So I'm asking the court to, and I know that there were some rulings already when there was a question of this witness as to what needed to be turned over, produced, all the rest of that. And the court did sustain the objections with regard to the knowledge of the witness of the court system on the foundation objections that were made under 50.025 and 52.015. But I am concerned that there's going to be further questioning now about the conduct here, and that will be somehow argued for the punitive damages, and conduct of counsel in carrying out litigation cannot be a basis and is not a basis for punitive damages by the jury. So I believe a false issue is being raised. To the extent that we got into any of that yesterday that wasn't otherwise sustained on rulings, I would move to strike any of that questioning from yesterday as well.
Oh, okay. You have bundled a lot of things in there. And the reason why I said whoa is, please cite me any Nevada case that says after the questioning is done for the day, and you had a full opportunity to object, that somehow you haven't waived your right to object and that somehow you can bring it up in administrative matters outside the presence of the jury the following day or some other type of similar situation. Counsel, that's the whole idea of objecting, unless it's such an issue, right? The court should intervene, but you all objected when you wanted to, question by question.
Yes, Your Honor.
How can you say, and remember, this is administrative matters, folks. This is not, this is pre-issued and dealing with quick administrative matters. If not, it needs to be questions. You've raised a plethora of different things. First off, I want to be clear. If anyone is contending that this court did not rule on anything that it's supposed to have ruled on, I need to know right now, and I need to know what it is, because attorneys are charged with bringing to the court's attention. If not, it's waived, okay? There's certain things that have been deferred with specific directives to attorneys to be doing things. You all haven't complied with that, okay? Already had to point out one when the issue came up, okay? Regards to violations and opening statements to direct motion eliminate, see document 1092, right? Motion eliminate number 14 of your client. That being said, parties have an obligation to object timely. There's a whole plethora of Supreme Court cases, right, with a timely objection. What Mr. Smith may have handed to Mr. Wade and handed to you may be a different situation depending on which case he's citing, but
The 2022 Cox versus Copperfield, the situation in which there
I'm
was
very
a,
familiar with the situation outside the presence of jury with the non-Marcus Judge Denton's case, yes. I'm
even though there was a-
familiar with that case, go ahead.
oh, I'm sorry, and even though there was a time delay in that setting, considering that the issue is serious enough, the court said even though there was some time frame in between the two, on Cox versus Copperfield, 507 P3rd 1216, 2022. The court said that still was appropriate for the court to make sure that justice was done as to whether or not comments made by counsel in closing were appropriate or not. And then under the OC versus Cohen, plain error can always be raised later. And I just want
It's plain error for the court not to address something that you all did not raise objection to when you raised multiple objections to specific questions, and this court reminded you at bench and in open court, question by question, and I reminded you it was your obligations to object and give the evidentiary basis of said objections to do so. So it's not a Leochi issue, and remember, that was a closing argument issue with regards to a plethora of different things after the jury presided. It was not a in the middle of witness trial aspect where parties did object to questions by questions during the course of it. So I'm hearing what you're saying, but are you saying that they are factually similar and the court should be using a similar analysis?
No, the general analysis is the same, and the way of looking at the issue is the same. The timing for closing arguments is different from, just factually, from the interrogation of a witness. But in any, I do that, and I know we were trying to object to a number of these, and a number were sustained.
What time you did. You objected, the court addressed every single objection. A couple of you wanted it benched, the other ones you wanted after the presence. The number of times you brought the jury out so you could address them, right?
Yes, Your Honor.
Okay, so you gotta pinpoint what your issues are, because you bundled in a lot of different things.
I did.
So realistically, this is supposed to be administrative issues. If somebody's gonna be bringing in motion practice, you gotta give the other side a chance, an opportunity to respond and evaluate. But let's walk through what you're saying. And our poor jury, that's why I asked you all at the end of the day, right? Each day, if you think you're gonna bring something up to the court's attention, let us know. So we don't have a jury sitting out there waiting, but, okay.
Yes,
So
and
you said
I did have a brief conversation with Mr. Parker earlier. I don't say that it's wide-ranging at all. Just told him I would be arguing this point in a very generally.
But you didn't let the court, and most of the court, come out with jurors. I mean, that's really, okay.
Understood.
Let's walk through it. You said conduct of counsel cannot be a basis of punitive damages. Are you saying that the conduct of counsel with regards to the withholding of the various documents that the court's already ruled on?
In my statement,
Counsel, because Mr. Parker specifically said he was not attributing it to counsel. So I need a clarification of what you mean by the conduct of counsel. Are you saying it was counsel's issues, not your client's issues on the documents?
if I did say that, I'm not aware of having said conduct of counsel. No, if I did, Your Honor, I would ask to just amend that to say conduct of the parties. In this case, the conduct of the party.
Once again, I need to know the scope. I'm just trying to get the scope of what you're throwing up. If someone uses the phrase spaghetti, I mean, I'm not saying it is spaghetti, but there's a lot of things being thrown out here and bundled in here, so we need to focus it in. So, let's walk this point by point so the court's hearing the point by point. What are you objecting to or raising before the court?
I'm objecting to any questioning of the witnesses with regard to whether or
Witness by
not.
witness, it can't be, you can't do global, okay?
I'm sorry, Mr. Walters then.
I mean, as you can appreciate, you all have a full chance to do motion to eliminate, okay? And if you recall the time of the motion to eliminate hearing, and I appreciate you running the case at the time, but you got a whole row of people that were, okay? And so they may recall, because it was their motion in limine with regards to the pump advertisement one, right? And they recall that there was a sanction hearing number 1, right? That ended up having a memorialized order, I believe, after you had been. So, when we go to that everyone had a time to file whatever motions limited they wanted to. We had, I don't know, I think it was over 100 initially. Certain things got resolved, so we were less. But the orders is filling up more than a red well. Okay, so the challenge here is there's a training for global aspects. So if it's a particular witness, then I can address a particular witness. But global rulings, I'm gonna have to say, I have fair to everybody, right? You can't just bring up a whole bunch of things that should have been brought up previously with certain deadlines. So that's why I'm asking you to focus in on what actually is the objection, who it is to, what's the basis.
The objection is to questioning with regard to any non-compliance with court orders or any discovery miscues by this defendant, and with regard to what occurred only during the trial. The sanctioning occurred during the trial of this case, and the whom is Mr. Walters, who's the witness before you.
And you said something about that you're asking about certain non-objections from yesterday. Is that still you're asking for?
No, I just said to the extent, in the middle of those objections, I was getting objections sustained with regard to foundation and the knowledge of that witness with regard to duties of the court. But I'm sensing that we're going to have more questions now on the exhibits as to whether or not this party properly answered discovery and whether discovery came late, so that the jury is going to hear potential issues about discovery compliance, which is not appropriate for consideration by this jury in a punitive damages matter.
So, I'm sorry. You're putting a lot of things out there, right? And not in a proper format, so let's trying to understanding so that address all these, and then everyone else has an opportunity to respond if they have to know what they're responding to. So, you made a statement a few moments earlier, right? And then you cited Cox and Leochi, and before I asked you whether they were similar. Are you still saying that the court needs to address things that you chose not to raise objections to yesterday?
Yes, I do move to strike,
So
and
what-
to the extent there is any
You're asking to
questioning,
strike.
I'm sorry,
Counsel,
you're speaking.
If you're going
I
to
apologize.
ask for a motion to strike, right, you have to articulate exactly what you're asking to strike. What exactly are you asking to strike?
Any questioning yesterday that went to an alleged failure by this defendant to properly respond to discovery or inappropriately respond to discovery.
Counsel, isn't that a very subjective statement? Remember, the court, if you're asking for a motion to strike, right? If you were doing it right as testimony came out, okay? You'd be saying, you're asking to strike the last answer of the witness, or I'm asking to strike starting with the word one, okay? You are doing a catch-all, and, I mean, who does the interpretation of what is questioning regarding impropriety of different things, right? That's not a concrete aspect for the court to rule on, right? Because can you imagine how that memorialized, when people ask me these questions, I kind of think like, how does one memorialize that in writing, okay? And so usually it's a person said X, they want stricken, right? Or they want a witness stricken, or they want an opinion number blank stricken, okay? It articulates what action is being requested. They're very amorphous, right? Isn't then asking the court to subjectively, which I cannot do, figure out which of those questions might have fallen within there, and then the court would sua sponte, strike them. Do you understand? I'm trying to get the grasp of what you're trying to actually ask the court to do, because without any specifics, it's a challenge to have an understanding of what you're asking the court to do.
Just strike the questioning with regard to any duty by this defendant to respond to the discovery that wasn't otherwise stricken on the basis that the witness didn't have that foundation to be able to answer it. I don't know honestly if there is anything left in there, but to the extent there is, I'm trying to make my record on having moved to strike that, Your Honor.
Have you, so I think you phrased two different things, right?
Oh, the second,
Objection and then a motion to strike. The object, right? Is that the two areas?
yes, and then the other is just going forward for today. I'm asking the court to not allow counsel to question with regard to alleged party misconduct in responding to discovery, as that's not causally related to the injury in the case for the punitive damages, and it's not properly within the jurisdiction of the jury to analyze discovery sanctions. That's within the jurisdiction of this court, and this court has taken that issue on.
Okay. Counsel, I am fully appreciative that you would have your people come into this case. Someone on your team should be mentioning the court order already on this topic. Maybe they haven't informed you, or maybe you didn't read the court's order. Okay, because part of what you're asking is probably the court order, what's gonna happen. And the reason, I will refer you to the document at issue. Does any of your team want to do this? Okay, you know what, I'm gonna let, in fairness, Plaintiffs' Counsel, I'm gonna let you respond, and maybe someone on your team, of all the multitude of people, might want to give you a heads up about something that the court's already ruled on.
Your Honor, that's kind, and thank you.
Okay, I mean, folks, you all need to, you can't say you don't know about things that are happening. Okay, we got too many of you. That's a different issue. So, Real Water, do you wish to be heard on any of this?
Your Honor, Joel Odou for Real Water. We do not, thank you.
Counsel for Plaintiff, would you like to be heard on this?
Your Honor, I want to be as brief as possible because I know we have that jury waiting. And you ended here, I was hopeful the court would start. And Terrible's had 18 lawyers by our last count. Not all of them are here, but certainly they have to be familiar with the court's rulings on this topic. The other thing that I would want to point out, and this is not a criticism, I know Mr. Boho is new to our jurisdiction, but our jury instructions allows for questions related to credibility of a witness. It allows, that's pattern jury instruction 2.07. Pattern jury instruction 2.04 allows us to ask questions about interrogatories. Pattern jury 2.05 allows us, and this is by way of example, Your Honor, you're familiar with this, allows us to ask questions about requests for admissions, Your Honor. Everything I've been asking this witness, and you did correct me, and the court sustained objections when I used words that were, I will say, legal jargon that could be confused with a production requirement under the statute or under the rules versus simply his desire to check his own documents to provide it to Mr. Kemper. And I corrected it or withdrew the question, or simply the court sustained it and I changed the question. The point is, there were no objections made that the court did not rule upon, or did I not withdraw the question, so there would be no issue for the court to take. To do so at this point, Your Honor, there is no case law supporting it. In the cases that we've seen all the way up to the ocean, still requires that you take affirmative action to make an objection at the time. You can't do it the following day and then ask for the court to strike some nebulous testimony from the prior witness testimony. So, Your Honor, I don't see where Mr. Boho's request can be granted. I don't know what remedy there would be. Certainly there's nothing supported under Nevada case law. And, Your Honor, under NRS 50.075, credibility is always something that you can question a witness about. And this witness's testimony has been all over the place. And I've not said anything about the attorneys doing something incorrectly. It's only been the conduct of the defendants themselves. And I've also instructed more than once when I've asked questions. I said, please tell me in response to my question things that you learned outside of counsel. So, Your Honor, I've taken all the precautions to make sure that I've not made this an issue attributable to Terrible's counsel. I've asked questions based upon the production and the searches that Mr. Walters has done, or failed to do. Oh, by the way, Your Honor, and this is something Mr. Pepperman pointed out, the exhibits I gave today that have been replacing the old exhibits, those were all agreed to and they were used during the opening. There were no objections to those exhibits, so I don't suspect there should be, those have been waived at this point.
Well, okay. As you can appreciate, I'll have the benefit of a couple of different things. And I told counsel for the meeting on behalf of ETC one, I gave him a chance to consult the rest of his panel of attorneys with regards to a ruling that the court already made. Did you have a chance, did somebody enlighten you by chance on the court's ruling? Mr. Boho, I'm not trying to put you on the spot, I'm trying to give you the benefit of the doubt, because you're the newest person into this case. But the court made rulings, and everyone's supposed to be aware of rulings.
I looked at the ruling in 619, which is the plaintiff's motion to strike our answer for lesser sanctions in relation to the admission of the jogging and the BMX video. And
Paragraph 32, area.
okay. And as I'm understanding that there is potential for a curative statement by the court or other instruction to be deferred.
Did you understand you were arguing to the court that the court can't do that? The court's already made a ruling that it will be done. That's what the court wasn't sure if you were aware of, right?
Appreciate it.
Okay, so realistically, the time has passed for any motions for
I'm sorry.
this is
I was listening. I'm sorry, Your Honor.
So, at this juncture, the court has heard the arguments of the parties. The court has already made a ruling in part. The ruling is notice of entry of order on the ruling. The date of the actual order, and we discussed this before, the order was dated 1/17/2024. The notice of entry of order was shortly therein, and this, of course, was from the December 20th, 2023 hearing. Paragraph 32 of said order, as the request for a curative statement regarding the discovery failures, the court defers the request of such a sanction until the parties have been able to draft a statement and is before the court to review. So the concept of allowing a discovery sanction statement is already law of the case. Whether the parties have chosen to present anything to the court as of this juncture really becomes the issue which the court mentioned beforehand when we were doing the second sanction hearing. So the court does not find that raising an issue, when it's raising an issue that the court's already ruled on law of the case rather than following the proper format of, if you were filing a motion for reconsideration, etc., that it's even properly before the court. Okay, I have to take that position because I made a ruling, there's a whole process under the rules. If somebody disagrees with the ruling, they will not follow. Okay, I'm not saying that there was any intentional comment by the counsel that was stating it, because I'm recognizing he's the newest person in the case, but when you have multiple attorneys, if you're gonna raise this issue, realistically, remember, you have to raise issues in good faith. And since the court's already directed the parties, because we have a similar issue, when we had the second one, with regards to what was the ruling of the court from January 17th, the court already reminded the parties, so I can say I'm a little concerned why no one seems to remember that this issue already came up. The court already reminded people of the very page of the order that I'm having to remind people of again. Then, there's another challenge. Mr. Boho, do you recall mentioning with regards to earlier in this case in front of the jury about that the gentleman were going to hear about documents that we didn't provide on time?
Yes,
So you're asking me to strike your statements to the jury?
I am not, Your Honor.
So only plaintiff's statements to the jury and not your statements to the jury? How would that be fair?
No, the difference is there is, as counsel said, there's some level of what, being, from a credibility standpoint, allowing to put in a statement as, did you make a statement at one point and did that turn out to be inaccurate based on further information? So it'd be similar to a deposition. If somebody had said something and it turned out they changed it and they confront them with that. So there is the line between just credibility, and which I addressed in some of the questioning from yesterday addressed, and it's why I didn't start objecting earlier yesterday. I believe they're entitled to have some level of questioning with regard to credibility. It just can't get into what you produced, and you were supposed to produce this under court order. It's just factual. Did you make such a statement? Did it turn out that statement was inaccurate for some reason? That's the factual end that I believe is appropriate. But did you miss court orders and somehow do something inappropriately in responding to discovery? That's not an issue before the court. Before the jury, that's an issue before the court.
Counsel, are you saying that anybody's engaged in such conduct? Already? You're saying that they've asked those questions that you're talking about?
When it got into the producing, didn't you know you had a duty to produce these, that sort of question? Now, I believe those were already sustained, at least on my objection, if I didn't catch every one of them, but I was objecting to him having the ability to have legal knowledge or have knowledge outside the attorney-client privilege, and you did sustain those
So
objections.
since the court has sustained the objections, you can understand why I have to keep asking you the question. I'm trying to grasp what you're actually asking the court to do. Because I'm hearing on the one hand, the court sustained everything that you objected to, and it doesn't seem like you disagree with the court sustaining, right?
I do not.
Okay. Some hypothetical that a question may have slipped through that you would object to. The court has no idea what's in your mind and what you chose to object to and not object to, or any other counsel. So that can't be an issue for the court, because if you thought it was objectionable, you got 5 attorneys here, and sometimes you've had 6, sometimes a minimum of 4, right? And you all are coordinating with each other, so it's very hard to say that many experienced members of the legal community, of a variety of different legal communities. Someone didn't say to object, okay? And we're talking the next day, so, and you even said hypothetical to the extent that they may exist. So I can't rule on something to the extent it may exist. Sorry, I gotta go back to this crystal ball, it's been so handy. Okay, it's the wonderful crystal ball that doesn't work that I got from my extern, right? Okay, very nice gift, wonderfully, it's beautiful. But it doesn't let me see into the future, nor read people's minds. So I can't see how I can address that, because you haven't provided me any way that I can, or anything concrete for the court to actually address. A hypothetical that you may have missed raising an objection, and you got this many attorneys, or even if you didn't have this many attorneys, I'm not being negative, I'm just saying, you have the benefit of having an amazing legal trust, okay? All of you all do. You know, compliment to everyone. You've got a lot of experienced attorneys, right? Whether they're currently presently sitting in the courtroom, have been in the courtroom, or will be in the courtroom, okay? I've signed enough prohocs in this case that there's a whole plethora of people that you even got remotely, okay? So I have to look at the fact that there's nothing concrete that you're asking the court to rule on with regards to any prior testimony of Mr. Walters. Anything that was brought to the attention of the court, which is the attorney's obligation, and you did it both outside the presence, and the one that you just mentioned with regards to production was actually the one that you all said partly at bench, because that was the one that you all wanted to hear, that one at bench. And if you recall what the court said to you all at bench, and I'm paraphrasing myself, is that I basically said with the words kind of producing, that was a legal-based term. So that did, and that was part of my reasoning that I gave, and since you all wanted that at bench. And then Mr. Parker said, where's the fact? Oh, that makes sense, I'm gonna rephrase the question, I'm gonna withdraw and rephrase the question. And they asked it in another manner. So I'm balancing everybody's time, knowing everybody else. I know you want to get forward with your case, but also making sure I fully address all these issues, because there's a whole bunch of them that appear to have been presented. So the court's ruling is going to be a post hoc after the day objection, because you chose not to object timely, and you can't give the court any specifics of why you couldn't object timely, or why there wasn't any basis, and it's speculative whether or not it even covers things that weren't already covered. You can appreciate the court's gonna have to say there's nothing for the court to rule on, there's no right issue. I am fully familiar with the Cox case, because remember, that is impeachment by contradiction, right? That was an impeachment by contradiction case, and that was a different concept. There's a couple other concepts therein, but that does go to credibility. And remember, even in that case, the impeachment by contradiction was an impeachment concept about whether or not they can impeach with some of the verbal testimony and some of the actions. The issue with verbal actions and actual actions. The person was how they were walking, etc. Right? That came up during the case, and whether it could, and the Supreme Court affirmed Judge Denton in that regard. So I don't see how that applies to here, unless you can take it in the very general concept of what is the scope of what you can impeach on and do it so, if you take it in the impeachment context, if you can impeach by contradiction, then realistically, I see it more lying in favor of plaintiffs than your argument, but it's going to the concept of the credibility component, right? So I have to look at the credibility component. There's nothing you presented to this court that there was any improper question. I'm going to clarify one point. I appreciate that Mr. Parker has raised some pattern jury instructions. As you are likely aware, there's a couple of Supreme Court cases that you can't rely on pattern jury instructions as aspects of law because some of those pattern jury instructions, there's a whole bunch of reasons. That's, I take it as an example, but it's common practice. I'm not taking it as binding case law in which a court can make a decision on a pattern jury instruction. So a little segue there. With regards to your prospective objection, the prospective objection I'm going to have to take as the way the rules are. If there is something that is a question that is evidentiarily improper for the basis, then the parties have a full right to do that question by question. The parties had a full right, if they felt that something was at issue, to have presented it in all the various deadlines for all the various motion practice. The parties also had, in this particular case, additional opportunities because you had 2 sanction hearings. Parties had a full opportunity to express whatever they wanted in the sanction hearing, to object to whatever ruling the case was, and here even more so. Paragraph 32 of the court's January 17th order, right, which has no entry thereof, and is law of the case, is instead of just granting some statement to the court, I was allowing all parties to have an opportunity to weigh in on it. So you knew something was potentially coming, and it was if you wanted it, you had to meet things, and people would have a full opportunity to address it. So as far as the due process aspect here, and the fact that discovery issues were going to be coming before the jury, everybody knew that. They knew it back on December 20th when the announcement from the court, then memorialized in writing. The reason why was, you don't really want me to go into the fact the reason why the ruling was delayed is because your firm didn't get things in timely and properly, right? So that delayed the court being able to address things. But that being said, I'm not taking that against anyone. I'm just saying that's why there's a little bit of time frame between, not the only reason, but it's one of the reasons why there's a time frame between when the ruling was, right, and when the court could actually look at orders. That being said, so you have an order, you have a participation aspect if somebody's requesting it, so that part's taken care of for the process. Then I have, in this case, I have the additional aspect that you, Mr. Boho, already said in front of the jury about, you're going to be hearing about these discovery issues. I'm going to have to paraphrase you right now because I'm going to have to pull the exact language you said, but you did address that already in front of the jury. So I can't say prospectively that I need to preclude someone to respond to things that were already said in front of the jury. The extent to which they do, that's not opening a door, that's definitely not a sliding glass door or anything like that anything's being open, but it's allowing this case to proceed in the appropriate manner so that proper questions can be asked. If anybody feels that a question is inappropriate, we'll set forth all the various objections you can make and the court will address them. I believe with regards to the actual exhibits, the court's going to now have to address these exhibits if and when they're sought to be offered, because from a couple of different standpoints. One, there's been an issue raised that these documents, right, these proposed documents, and when I'm saying proposed documents, it's the listings documents that Mr. Parker says with regards to replacing the paper copies with electronic copies, that some of those were referenced during parties' openings, etc., without objection. In order to address that concept, if the issue comes up, you can appreciate the court's going to have to ensure whether that's accurate. I'm not saying it's inaccurate or it's accurate. You have to see which document was referenced, how it was referenced, and for the court to make a well-reasoned ruling. I can't do anything right now because there's nothing directly presented to me. So I'm really going to treat this as a thank you for the heads up. And we're going to, at this juncture, there's no ruling the court can make that anybody's provided me any legal basis that I can make in light of the facts and circumstances and applicable case law. That's where I'm going. So, thank you so very much for the heads up. And at this juncture, is there any other matters that are...
Thank you, Your Honor.
Nothing on behalf of the plaintiff. We're ready to go whenever the court is.
Court's ready. I'm sitting here, I've been sitting on this bench for hours already, okay? We've already gotten through 14 other matters, whatever before your case, whatever the number was. Okay, so, counsels, are you ready to proceed to bring the jury in?
We are, Your Honor. The only question I have, and I want to make sure, I think there's no objection from real water, and I believe there was no objection from ETT or Terribles on these documents.
Be clear on which document.
So all the ones I provided earlier, there was no objection, they were used during the opening, there was no objection made at that point. It's my belief during the meet and confer, there were no objections to these documents whatsoever.
I thought I just heard Mr. Boho object.
This is the first time, he didn't object during the meet and confer, is my understanding, Your Honor.
Okay, you understand that's brand new fact that you're saying to the court after the court made its ruling. So I already said with my ruling that to the extent these documents, if they're sought to be offered, I'm gonna have to address any objection at the time that they're sought to be offered. Because what was presented to this court, at least as of the time I made my ruling, like I said, hence my Hydra comment the other day, okay? And the ever-changing landscape is that what was presented to the court, we only had an opportunity to engage in oral argument if they wish to do so, is that there's a difference of opinion whether they're objected to or not, whether or not they should or should not come in, so I'm going to address them when they're sought. If and when they are sought to be admitted.
Yes, Your Honor, that's fine with us.
Unless you can get an agreement right now, you can circle around and see if you get an agreement right now, if you don't. Okay, so y'all ready for the juries or something else the court can address for the parties?
No, I think we're ready, Your Honor.
Joel Odou for real water, we're ready.
ETT? One, you ready?
Yes, Your Honor, we are ready, Dan Boho.
Your Honor, can I put this on the witness stand? These are documents I intend to use that would probably make it easier. Some of these are new documents, they're not exhibits. I may just have them look at them, refresh his recollection.
But I'm gonna have, please get the consent of each of the other parties. If they're fine, the court's fine.
No worries, Your Honor.
Marcia, you can start to bring them in, let me know things much.
Your Honor, did you look at it?
No
Hold on a
objection.
second. I got the marsh right there.
May I approach now? There's no
Is there-
objection to the
Okay,
document.
let's just clarify. Okay, so the binder that Mr. Parker has in hand, does anyone have an objection for being placed on the witness stand? Real water?
Joel Odou for real water, we do not, Your Honor, no objection.
ET? I'll wait till you're finished talking.
No objection to putting it on the stand.
Feel free. Good. Y'all ready for the jury to come in? As much as they may be enjoying the wonderful hallway, y'all ready for the jury to come in?
Yes, Your Honor.
Mr. Parker, you ready?
Oh, I am, Your Honor, I'm sorry.
Councilman ET, ready for the jury to come in?
Yes, Your Honor.
Thank you, Marshall. Let's bring in our jury.
All rise, please, for the jury. Your Honor, all members of the jury are present. Everyone, please be seated.
Appreciate it. Welcome back. Hope everyone had a nice relaxing evening. Hopefully not taking bets on the timing that I estimate versus the timing that we're actually starting. We're doing our best to try and get you all taken care of. And you can appreciate counsel right here. We're working on a lot of issues just to try and get things minimized. So apologies, it was a little bit longer. So at this juncture, counsel for plaintiff.
Your Honor, may I have the marshal bring Mr. Walters back in?
So the same witness is going to be on the stand who was on the stand yesterday. And Marcia's going to go bring him in pursuant to the prior agreement. The court is also going to be reminding him that he's under oath when he gets here. Thank you so much.
Thank you.
One step up, Mr. Martin. Watch your step and have a seat.
Okay, it's been the process with regards to the trial. What we've done is we have just reminded the witness on the stand, rather than swearing you in each day, just reminding you that you're still under oath. Do you understand you're still under oath?
Yes, Your Honor.
Appreciate it. Thank you so very much. Counsel, feel free to continue with your direct examination. Thank you.
Thank you so much, Your Honor. Good morning, Mr. Walters, how are you?
Good morning, how are you?
Good morning, everyone. Good morning. Good morning. Happy Wednesday. Mr. Walters, I want to kind of do a recap of what you told me yesterday, and then start there and move forward, okay?
Okay.
And I'm doing this just so we can bring to mind some of the comments, okay? And make sure that they haven't changed between yesterday and today.
Your Honor, I'd object to just rehashing all of yesterday's testimony. If it's a couple of lines, I don't mind at all, but I don't want to have a lengthy.
I do appreciate it. The jury will disregard the colloquy between counsel, so the objection is counsel. To the extent it's a prospective asked and answered, all parties are aware of the rules. Feel free to proceed with your examination.
Thank you.
Thank you so very much.
So, Mr. Walters, yesterday, I believe you informed the jury that you had a conversation with Mr. Kemper regarding communications in November of 2021, is that correct?
Yes.
When you spoke to Mr. Kemper, he asked you, or did you ask him regarding communications with Real Water?
He asked me.
And when he asked you about communications with Real Water, could you tell me exactly what he said to you to the best of your recollection?
He asked, where did we get Real Water from? He asked if I had any documentation on communication with Real Water. That's all I recall.
Okay. And when he asked you that, did he ask you whether or not you had any communications verbally with Real Water?
No.
Did you inform Mr. Kemper that you'd had conversations with Real Water representatives prior to November 2021?
No.
You didn't tell him that you had conversations with Anthony Randolph?
He didn't ask specific conversations. He asked if I had any documentation with communication documented with Real Water.
Okay, but you understand that that is a communication. I mean, you and I talking right now is a communication, correct?
Yes.
It may not be in writing, but it's still a communication, correct?
Yes, sir.
All right, so when Mr. Kemper asked you about communications, why didn't you inform him that you've been having communications with Real Water representatives?
I didn't recall how often or if I had conversations or who at that point worked for Real Water.
Wait a second. Mr. Randolph testified here on Monday that he met with you somewhere between 10 and 15 times. Do you not recall ever meeting Mr. Randolph?
Over 10 or 15 times over the years, yes.
All right, and you had communications with him, correct?
Yes.
And you chose not to inform Mr. Kemper of that in November of 2021?
Correct.
And you also chose not to tell him about the pump and pour, correct?
I wasn't aware of the pump report.
How about the commercials?
I wasn't aware of the commercials.
So who within Terrible's would have had this information, whereas the vice president of purchasing and sales would not know about this?
The video monitors that Pump and Pour on were implemented in 2018.
Okay, but you've been there all that time, correct?
Yes.
Okay, how would you not know, through your conversations and meetings with Mr. Randolph, about the commercials or the pump and pour, any of those discussions?
Our discussions was purely on the promotion of the water, the price, the retail, the placement in the stores.
So is it true, and Mr. Randolph testified to this on Monday, is it true that you and Mr. Randolph discussed the price point for the Real Water?
Yes.
You discussed the promotions for the Real Water?
Yes.
The marketing?
If you consider marketing the retail.
All right. How about the 30 by 30 inch stands or displays? Did you discuss that with them?
I don't recall.
Did you discuss the coupons and the buy one, get one, buy two for $3?
There wasn't a coupon involved. That was the retail.
Okay, do you recall increasing that? Mr. Randolph said that Terrible's decided to increase the price from $3 for 2 bottles to $4 for $2 for 2 bottles. Were you aware of that?
I don't recall when that took place.
Do you doubt that Mr. Randolph was being honest when he said those things?
Objection, Your Honor.
Evidentiary basis?
You don't, this witness does not make a determination on,
Counsel, evidentiary basis.
with regard to, he doesn't have the foundation 50.025 and 52.015 as to the opinion in the thought of another. It also be speculative 50.025 and 50.265.
Sustained on speculation.
Thank you. Mr. Randolph testified that there was a change made by Terrible Herbst from 2 bottles for $3 to 2 bottles for $4 because Terrible Herbst wanted to make more money or profit on that item. Is that correct?
I don't recall.
Is it fair to say, Mr. Kemper, that in order to display the 30 by 30 displays, Real Water displays at Terrible's, someone at Terrible's had to give authority to do so.
Counsel. So what do you need to say, Mr. Parker?
No, I was asking if he, Mr. Walters, sorry, Mr. Walters, if I called you Mr. Kemp, I apologize. I'm thinking ahead. So, Mr. Walters, is it fair to say that someone from Terrible's would have to authorize or approve the displays of real water, I'm talking about 30 by 30 displays, at the pump or within your store?
Yes,
Same with the commercials,
yes,
same with the coupons,
yes,
same with the pump and pour general.
yes.
There's no dispute, I would ask, that real water couldn't, surreptitiously sneak into your stores and do all that themselves.
They absolutely could. We've had people put up unauthorized signs before in the stores.
No, I'm talking about the signs. Okay, fine, let's
Absolutely.
say the signs. Eventually, I would think you would see them and pull them down if they didn't have authority, correct?
The store level would, yes.
All right. But how about the coupons, the pricing, the commercials? They couldn't do that without Terrible Herbst doing it, right?
Yes,
Same with your Facebook,
that's managed by us, yes,
same with your Instagram,
yes,
same with your TikTok,
yes.
all your social media. That would have to be controlled by Terrible, correct?
I don't manage it, but I believe so, yes.
Thank you. So, Mr. Randolph said that he visited with you 10 to 15 times. Were you aware of Mr. Randolph's inclusion of Terrible Herbst in his business plan?
No,
Did Terrible Herbst back in the 2018-19 time period have approximately 100 stores within Clark County?
approximately 100.
And we've shown in the business plan that the 30-second commercials were being played at roughly 100 locations at Terrible Herbst and had good feedback on that. Were you aware of that at all?
No,
As Vice President of Purchasing and Sales, should you be aware of that?
no.
Who at Terrible Herbst should be aware of that?
The Vice President of Advertising and Marketing,
And who would that be?
Brian Breeden.
He would not have to come to you to get approval for any of those commercials.
I would advise if it was a product that should or should not be. There's criteria that you need to meet to be on there.
And you just don't recall Mr. Breeden informing you or providing you with any commercials for your review and approval?
No.
And you don't recall the pump and pour being provided to you for your approval?
No.
And you don't recall the pricing? I'm sorry. You do recall meeting with Mr. Randolph about pricing?
Yes,
All right. When Mr. Kemper asked you about communications, did you ever discuss with him the pricing decisions you'd made with Real Water?
no,
How about the marketing decisions?
no,
Promotional?
no,
So when he asked you about communications, you just gave him an answer based upon your one search in November of 2021 on your own email. Is that correct?
The pricing communications, the pricing is presented to us through Nevada Beverage.
Okay, but you just said you had a meeting with Mr. Randolph and you discussed pricing.
There was an email discussing pricing, yes,
All right. And
but
you
all
didn't-
pricing is submitted by Nevada Beverage.
Did you provide, that's fine, did you provide Mr. Kemper with that information? That you had conversations with Real Water about pricing?
No,
Yesterday, we were talking about documents that you provided, or that was provided late by Terrible in this case. Do you recall that?
yes,
These are those documents I will represent to you. If you want, I can have you take a look to verify, but these are approximately 290 pages of documents. That's not that, that's different. Those are some exhibits we're gonna go through later on today. But these are the documents that were provided to us, I believe January 18th.
I believe January 15th.
Objection, Your Honor.
Okay, hold on a second. Pause for a second. I have an objection. Basis, go ahead, please.
the form of that question with regard to the 47.050 and 61.065 of that grouping as a whole, as opposed to any one individual document. Just a statement of purpose.
Recorded, we found some really white noise. We appreciate it. The objection was denied without prejudice. Counsel, you may feel free to move forward to the next question.
Thank
Or
you.
rephrase your question where you need to.
No, I'm fine going forward. So, as I was saying, Mr. Walters, this binder, not the one in front of you, are the 290 pages that were produced on, I think, January 18th, after we started trial, picking the jury. Okay? Did you go through these documents by chance?
I did not.
Did you ever see the documents that were eventually retrieved that actually had the words real and water in them, the same search terms you said you used?
Objection, Your Honor. For the reasons earlier.
Okay, evidentiary basis, please.
For the reasons raised in the earlier discussion today.
Counsel, your approach, please, Madam Clerk, please, tell what noise again, please, thanks so much. Very much. Okay. At this.
I'm assuming they're gonna make their objection on the record, John?
I will pause it for.
Yes, Your Honor, we object on the basis of materiality and relevance. And we do request a hearing on this, Your Honor.
Okay. So, ladies and gentlemen, once again, we're not gonna have you come back, and I'm not gonna bring back bench and take time, right? We wanna make sure the most efficient way is the one to go scripture way, it's okay. So, ladies and gentlemen, we're gonna take a brief 10-minute recess. During this recess, you are admonished not to talk or converse among yourselves or with anyone else on any subject connected with the trial. You may not read, watch, or listen to any report of or commentary on the trial or any person or entity connected with the trial by any medium of information, including without limitation, social media, text, tweet, newspapers, television, internet, radio. Anything I've not stated specifically is also included. Do not visit the scene or the events mentioned during the trial. Do not undertake any research experimentation, excuse me, or investigation. Do not do any posting or communications on any social networking sites or anywhere else. Do not do any independent research, including but not limited to internet searches. Do not form or express any opinion on any subject connected with the trial, so it's fully and finally submitted to the time of jury deliberations. Thank you much.
All right, for the jury, please.
Appreciate it. Do you wish this witness to be outside the presence during
Yes,
this oral
please.
argument?
Yes, Your Honor.
Okay, since I've got that. Your lawyers in the anteroom. Okay, appreciate it. Can't have you near where the jury is, so, anteroom?
I'm sorry, I'm just sorry.
No, everyone's here, please. Okay, thank you so very much, appreciate it. So, counsel. Materiality and relevance. I will tell you the court's inclination and you can argue. Materiality, not an objection in Nevada, an evidentiary objection at time of trial, so the court would have to overrule that objection. With regards to relevance, at this juncture, based on what's currently presented in the current posture of this case, the court's inclination only is to overrule the relevance objection to that specific question. That's just an inclination, and if you all want a reference point to part of the reason for the court's inclination, I would refer you to page 73 of the transcript from January 26, starting probably around line 14. Probably a little bit higher. Okay? So, counsel, you raised the objection. Please explain your relevance objection, and I'll let anybody else respond who wishes to.
Yes, Your Honor. An issue of the conduct of a party in relation to discovery would not be a relevant consideration at this point. It's irrelevant because it's precisely the issue of getting the witness to testify about the conduct in response to discovery after the injury to the plaintiff here. So it would have no positive connection, and secondly, because it's raising in front of the jury conduct that is in the jurisdiction of the court and not in the jury.
When I said page 73, 73 was a page referencing the 290 pages. ghosted, I probably should have said page 72, it starts around 71, 72, starting with. Okay, so real water, do you wish to be heard on this?
No, thank you, Your Honor. Joel Odou for Real Water.
Council for Plaintiffs, do you wish to be heard in response to the relevancy objection?
Your Honor, I think the court's already, the
No, I, it's
inclination
an
is correct.
inclination, you all know. I give
That's fine.
inclinations to try and assist you. I have a point of reference, but I'm relying on an inclination. I try and give you this a heads up so everyone can look at it. Everyone's on the same equal footing. Go ahead, please, if you wish to.
Yes, Your Honor. Again, as we said at the bench, Your Honor, Mr. Boho in his opening made this reference, made this point, a point in his opening regarding the documents were being provided late, had been provided late. We will hear about documents being provided late. He knew it was relevant at the time. He tried during the opening to do some kind of mea culpa before the jury could hear the actual evidence play out. The other thing that he's trying to do, and perhaps he's trying to conflate the court with this issue, we're not suggesting that his discovery abuse had anything with real water creating hydrazine. Their whole point in this case has been to distance themselves from real water. We're showing the connection between real water and Terribles and how Terribles took it upon themselves to deal with promotional information, marketing information, how they could sell more and more of this product in conjunction with real water. And now they want to distance themselves after selling over 10 million bottles because, and I'm just saying this is kind of what, you know.
10 million bottles, Council?
Well, that's what they say. In this case, in terms of 2018 through 2020, we know they sold 371,000 bottles. That's something we do know. Because we don't have the records, unfortunately, going further back to the other 8 years or so beyond. The point is, Ron, it is relevant to the relationship, it is relevant to promotional, it is relevant to punitives, and they're simply attempting to prevent this information from coming in because they don't want the relationship between the two to be put before the court, to be put before the jury in terms of evidence shown. So it is relevant evidence shown.
Okay. Here's where the court has to objection, response, and the court makes ruling, okay? So, Mr. Boho, you were standing, did you want a final word on this? Because
The points he just made were the questions I didn't object to. I didn't object to him what the relationship is between the parties and that, and what they sold. This is with regard to a discovery violation, which has nothing to do, as he just said, punitive damages. Discovery violations have nothing to do with punitive damages. That's a subject to either an instruction or a court ruling, not a jury consideration.
okay, court already addressed that concept at the time of the motion to strike hearing. So let's go directly to the transcript on January 26th, which is why this court has to, and I gave everyone the heads up, I gave you this page site, gave you 2 different page sites, gave you the date, time, and the page site of where the inclination was, is because here it is. I'll start at the beginning of page 72 of the transcript from January 26th. Mr. Boho during opening statement. Let's go, by the way, to a lot of time was spent on wrong answers. Where the answer to remember the things about discovery, you were given discovery in testimony and trial. Was there information? Did you give the wrong information with regards to prior contacts between Terrible Herbst and Real Water, and they say they misrepresented a lot of things. Here's kind of the key sentence that the court, in part, was relying on the totality, obviously, applicable case law. But in this particular case, I have the next sentence says, I think you will hear when you actually see the people on the stand that everyone, when they gave each bit of their testimony, testified honestly to the best of their knowledge. What happened is, you will hear the evidence on all of this. A search was done. You have to respond as to whether you have documents or not. Everybody had done a search, and it had been done globally through a litigation software, ESI, that went out and dug into all -- instead of the individual people trying to tell you what discovery -- what documents you have or not. The head of IT at Terrible Herbst did a global search for all of anything that had either the words, either I think real water or real and or water individually. In other words, real water together and real water individually. I believe that's how he did it. I just know that they searched real water and these didn't come up. On his global search, there is no archive feature. On the individual people, after a certain amount of emails, it goes into archiving. And what the head of IT understood from the documentation from Microsoft, when he did a search, he doesn't have the archive button. When he did it, he didn't pull that information. It was learned very recently, like within the last couple of weeks. An individual director within the marketing department, the internal marketing, meaning the product for Terrible Herbst, for the pump, and for the coupons and things like that, she was on a Mac because she was creative. Everybody else was on a PC. A couple of the creatives had Macs. When she did the search, she pulled up the document that had been pulled on the master search. So Terrible Herbst went in, dug into it, and then did a second search that somehow was able to dig into all the individual archiving. So they got documents late within the last, 10 days, 12 days. Does that reflect poorly on Terrible Herbst, my client? I think it does if you don't get it. It's your job to get this done right. But when we found it, we turned it immediately over. There were 290 pages of one kind of email or not, including change. So that is true, that they got the information late. That was consistent with earlier information. Now they've had the chance to look at it. There's a slide or two. I think they may have shown it here. They have talked with people in a court setting as to what exactly happened, so they do know all of this. So when they were telling you the information that was given was untruthful or bad words about it, it was dash dash each time somebody gave that, and you'll judge this yourself on the stand to the extent they want to ask any of this. But each time they said this is the truth, that was what they believed to be the truth based on a search, a global search by the head of IT. And then you go into the head of IT as a highly qualified person, you will see that. You'll make your own judgment. I can say, but you're going to judge yourself as to what you think of it. And when they found that there was dash dash, there was an archiving that didn't show on the global, that it has on individual machines, we turned it over. There's no document, there's no smoking gun that I'm aware of in there. We'll see we'll see what they say on it, but none of it changes any of the facts here that nobody at the time in September 2019 knew anything about the hydrogen being in the water. Nobody knew it was a danger. Terrible Herbst certainly knew less than real water, which itself didn't know by then because it dash dash Blaine continued to make it and continued to drink it. Thank you for listening. The reason why I read the rest just so that you get the full context. So, long version of why I overruled the objection. And so, because realistically, your opening statement has to be a good faith belief of what you think the evidence is actually going to show. And then an opening statement sets forth that people understand are going to say something with regards to a particular topic, then the court can't find at this juncture under these facts that it would be appropriate to sustain the objection with appropriate answers. The court needs to overrule the objection. Remember, this is question by question. Okay, that's the court's ruling. Would you like the jury brought back in?
Yes, please.
Okay, I assume that's yes from everyone?
Yes, Your Honor.
Yes, Your Honor, Joel Odou
Appreciate
for the
it.
water.
Thank you very much.
Good?
Oh, yeah, thank you, perfect. Yes, let's come back to stand when you get the jury. Thank you so much, Marshall.
Can I step back up, Your Honor?
Of course you can.
Thanks.
And everyone understands the court's ruling is question by question. It's not an entry for people to do things, nor is it shutting any doors. It's a question by question analysis based on court given objections. Thank you. Yes, Marshall, appreciate it. Thank you so very much.
Thank you for standing, everybody. Come on in, folks. Your Honor, all members of the jury are present. Everyone, please be seated.
Appreciate it. Thank you very much. Okay, that's that, ladies and gentlemen. You're in direct examination. Witness understands yourself under oath, and you know we took a break, correct? Appreciate it. Thank you so very much. Counsel, you can feel free to proceed.
And Your Honor, the objection is overruled.
Oh, I'm sorry. Yes, outside the presence of the jury, the court overruled the objections to that specific question. Counsel may proceed.
Thank you. And so you became aware, Mr. Walters, that these documents were produced in January of this year, January 18th or so this year.
Yes.
All right. When I left off, I was asking you about the search terms that you used back in November of 2021. Okay, you said you used the word real and water, correct?
Correct.
Did your, what kind of software system do you house your emails on? Do you know? Is it like
I
Outlook?
believe it's Outlook.
And does Outlook normally save all your email?
There's a size limit to your mailbox,
Okay,
but it saves all your emails, yes.
all right. So if you want to go back 5 years or 6 years, and you want to put in Anthony Randolph, for example, you could search that way. Is that correct?
I'm not an expert on how long it will hold everything. Yes, I could put that in.
So that's,
Thank you.
and if you want to put real or water, you could search that way as well.
Yes,
All right, and you just don't know how many years back it will go.
I don't know what it says.
So, when you looked in November of 2021, did you have Matthew Randolph assist you at all at that point? The ID, is it Rudolph, I'm sorry?
Yes,
Rudolph, I apologize. Did you have Mr. Rudolph help you at all?
no,
And did you have Mr. Sexton help you at all?
I did in January of this year, yes.
That's right. Why did you have him help you back in November of 2021 when you were first asked about it?
When I was asked to do an email search, I did the email search. I didn't ask for any assistance
I know, but why didn't you?
because I did the email searches I thought would search my email box.
Okay, and then when you asked, and then when you asked again in January, did you ask for help that time?
I did.
Okay, and who did you ask for help?
January 24th,
Yes.
Brad Sexton,
Okay.
our Chief Information Officer.
Okay. Now, I want you to take a look at exhibit 28, I believe. Don't pull it up yet, Chief.
This
Wanna
is
make sure.
proposed?
This is proposed, Your Honor.
Okay.
I don't believe there should be an objection to it.
Sorry.
28.
Wait. Oh, sorry, 22-8,
Yes, Your Honor.
Michelle has been admitted, is that, counsel, do you concur?
Real water agrees, exhibit 28 is already admitted.
Okay, Counselor TT, concur?
What's he trying to say?
Counselor TT, do you concur?
Would you
2-8,
select
okay.
right?
Oh, no worries, I just didn't know if you heard me. Sorry, sometimes I
Yes.
speak a little
Yes,
louder
Your
with wearing a mask, so sometimes I just need to refresh so everyone can hear me. No worries, thank you so much.
Yes. Yes, Your Honor.
Appreciate it, thanks. Yes, you may.
Thank you. So this is an email, Mr. Waters. Do you recognize it?
I recognize it, yes.
So when you did your search, you should have pulled up this email, for example, correct?
Is this an email?
Well, a letter, I'm sorry. That's a good point. Mr. Waters, does Terrible's keep a hard copy and electronic copy of documents?
Not that I'm aware of.
So a letter like this, would this ever make it into an electronic file at Terrible's?
No,
Okay, so where would hard copies like this be stored?
I'm not aware.
Okay, but certainly this is an email between you and the president of Real Water, correct?
I believe it's a letter, not
A letter, I'm sorry, a letter. And this letter talks about the pricing. It is confirming that Real Water will provide Terrible Herbst a $1.50 per case rebate on all cases sold in a Terrible chain of convenience stores for as long as in-store promotions and in-store video are active. You see that?
Yes,
Now, are you aware of the fact that Terrible Herbst denied having any videos? Objection. Your Honor, I don't know if they have any.
Evidentiary basis, please.
Yeah, Your Honor, irrelevant.
Counsel, can you now approach, please, Madam Court Reporter?
Thank you.
Appreciate it. Okay, court overruled the objection. Counsel, you may proceed with your rephrasing the question, restating the question, whatever you're doing.
Thank you. Mr. Odou, we're going to continue, okay? And if you could, put that back up for me, Mr. Crawford. Thank you so much. And as I was asking before, it speaks of in-store promotions and in-store videos are active. You see that?
yes,
Were you aware of the fact that at one point during this litigation, that Terrible denied any videos?
I believe the videos were talked about at the pumps, not in the stores.
It doesn't say pump and pour, does it?
No,
It says videos, correct?
in-store videos, correct.
And you've already admitted that you found, make sure we're clear on this. And I'll ask it this way. Wasn't coupons found sometime in November of last year indicating that there was pump and pour running in August and September of 2020? Isn't that correct?
Yes,
All right. So that was pump and pour. This speaks of in-store promotions and in-store videos, correct?
correct.
And isn't it true, using this document with this language that was sent to you, that Terrible's denied having any in-store videos, correct?
I don't know if they denied having in-store videos.
Huh? Did they deny in-store promotions?
No.
So there were in-store promotions.
If we have a product in the store, to me, a promotion is the price.
Sir, let's be direct with each other. I asked you earlier, if you sat down and met with Mr. Anthony Randolph in formulating promotions, remember that? I asked you about promotions, marketing, pricing, remember those things?
And I said that we talked about pricing, yes.
You also said you talked about promotions, you remember that?
The price for the promotion, correct?
Okay, so would you consider that to be in-store promotion, sir?
Yes,
Okay, so you're saying that only a price is a promotion, not a display, not a video, not a commercial. Those aren't forms of promotions as well?
a price is a form of promotion and so are the others.
Okay, good enough. Did you tell Mr. Kemper of these videos or in-store promotions that are referenced here in this letter?
I didn't see this letter.
But you knew that you'd receive letters from Real Water, correct?
Once this was circulated, yes, I don't recall getting this letter in
Yes.
2010.
Yes. And the next sentence or paragraph says, "Thank you for your assistance with this matter, and we look forward to selling a lot of Real Water with you." Did you ever respond to this letter?
No.
If we could go to Exhibit 22, please. I believe this is admitted, but let me check, Your Honor, before we put it on the screen. Shane, don't put it on the screen yet.
Pretty much.
That's what I thought. Yes.
Okay, concur, then. So,
Thank you, Your Honor. Now, this is a form of a promotion, correct?
Yes,
Now, are these in-store promotions or at the pump promotions? How would you describe this type of promotion?
these promotions are part of the pump and pour, which would be on the pump promotions.
And is this the document that you recall providing sometime in November of 2023?
I don't recall providing it, no.
Okay, do you know where this came from?
I don't.
Would this have been something that had to be approved by Terrible's before it could be used?
Yes,
Got it. And how does this work, by the way? Is it on a pump, I think is what you said?
yes.
Explain to the jury how this applause screen document works.
I will do my best, but Brian Breeden handles this side of the business because he is our VP of Marketing and Advertising. I know the program, so I'll do my best to
Yes,
explain. There is a still screen when you come pull up to the pump at a gas station, and it has, when you remove the nozzle, it has a screen that will come up with offers. On this occasion, there's 6 offers, and as you're pumping gas, you have the ability to touch one of the offers to print a coupon for whether it's a discount or a free pump.
All right. And so, is there a benefit that Terrible's gets when someone comes into the store to pick up that product?
The premise of the program is to reward our loyal customers
Yeah.
for fueling up the Terribles.
Right. So you get someone to buy your Terrible's gas.
And we reward them with a product or a discount on the product.
Right. And then when someone comes in the store, they're also available to look at all of your other stuff if they want to purchase, correct?
Absolutely, but they don't need to purchase anything else.
That's right. So there's a benefit for Terribles because they sell the gas and because someone comes in their store when they may not otherwise come in the store and perhaps buy other products, correct?
Correct.
All right. So for Terribles, this is a money generator, correct?
This is, like I stated earlier, this is a reward to our consumers for being loyal customers. And the reason I say reward, we don't require a fill-up. This is with any purchase of fuel, so different from our competitors. We're rewarding you if you buy a gallon or 10 gallons.
Right.
It's a reward for our customers.
Right, and your customer has to come into the store to redeem the award, correct?
Correct.
Go to the next page of this. So are you familiar with these coupons?
Yes,
And where do you get the coupons?
the coupons are printed from the pump's actually called a dispenser, and just where you print and get your receipt for your fuel, you get a coupon in that same area, off the dispenser.
And that's what you take into the store.
Yes,
Did Real Water give Terribles a discount on its water that was a part of this promotion?
again, I can't answer that.
Who would know that?
Brian Breed.
Would that be something agreed upon between Terribles and Real Water?
Terribles and the distributor, Nevada Beverage, yes.
Right, which would eventually get the water from Real Water, correct?
If there were discounts, as I stated earlier, the pricing and the discounts come from Nevada Beverage.
All right, but if we go right back to Exhibit 28, this was a letter agreement between Real Water and Terribles, correct? Where the pricing was established.
In 2010,
All right. And that was an agreement between Real Water and Terribles, correct?
again, I don't recall the letter from 2010.
You agreed to it, correct? I mean, you're the recipient of the letter.
Yes,
You had the authority to agree to it, correct?
yes,
And you can do that on behalf of Terribles, correct?
yes.
And you don't have anything that you can recall where you disagreed with that?
No.
And is it fair to say to this jury that Real Water was being sold at Terribles from at least 2010 all the way through 2021?
To my knowledge, yes.
And when Mr. Kemper asked you about any communications, you didn't recall the coupons, the applause screen, or that letter. Is that fair to say?
As I stated, the coupon and the applause screen would have been communicated through Mr. Brian Breed.
Okay. But you didn't remember the letter?
I did not remember the letter.
Good. So this is an exhibit that's already been admitted in this case. It is the actual business plan for Real Water. Did you ever see it? Just show the first page of it. This may not take very long to start.
Counsel, can you repeat the exhibit number, please?
23. I think it was introduced through Mr. Randolph, unless I'm mistaken. It was pre-admitted to you.
We just didn't get it from what you said.
Okay.
No.
Are we okay?
That's what it's being repeated, but we know it from the-
Thank you. Mr. Walters, did you ever see this document?
No.
Within this document, Mr. Waters, I believe it's on page 12, 23, page 12. If you could highlight the section on online 30-second commercial, please. The entire paragraph, please, and blow it up. It says here, our 30-second video commercial has proven to be successful for our targeted demographic. Using Google Analytics, the commercial can be pinpoint focused to our selected demographic. Also, the commercial is used for in-store and outside pump video display at various retailers. You see that?
Yes.
And then finally it says, it is done particularly well at the Terrible Herbst gas station chain in Las Vegas with approximately 100 locations. If you run the commercials at one location, do you typically run it at all your locations?
Again, that would be a question for Brian Breed. I believe they're in zones, but I can't answer that.
All right, good. were you the person in charge, Mr. Walters, of receiving customer complaints? Or were you ever aware of customer complaints?
No,
So you're not aware of any customer complaints related to real water purchased from Terribles?
no.
Who would be the person at Terribles who would collect those or be a recipient of those complaints?
I believe we have a loss control department that works with security, that receives all complaints.
Okay, so a customer had a complaint regarding the taste, the smell, that made him sick. You would be the person to handle it?
No.
That would be your, what department again?
Believe it would be our security, loss control, loss prevention.
Security, loss, control, and.
I don't know though, I don't know where the complaints go.
Okay, do you know who the director of that department is?
I do not know.
But it's not you.
Correct.
Do you know your IT people checked with that department to determine if there were any complaints that they received?
I'm not aware if they checked.
You've not been informed one way or the other if they checked, have you?
I'm not.
And you don't know if your department or any other department within Terribles has provided that information? If there were complaints, you don't know if such complaints would have been provided. Is that correct?
If there were complaints on products, then I would have received the information, yes.
Okay, so wait a second, make sure I understand. If there was a complaint regarding the taste, the smell, it made them sick, something like that, for one of your products, would you, in the chain of Terrible Herbst, would you get that information?
I would guess there's a chain of command, but eventually a product complaint could end up in my lap, yes.
Okay, I thought you just told me, and maybe I just didn't understand, that security, loss, control, and prevention would be the department that would handle that.
Initially, yes.
Okay. And so if they resolved it, would you still become aware of it?
No.
Okay. If they gave someone a free product in return as opposed to finding a problem, would you ever know about it?
No.
Okay, so then that goes back to the question I asked a second ago. You would not be made aware of all complaints regarding the product?
I would not be made aware.
Oh, good. So, for example, did you ever hear about a complaint from a Mr. or Mrs. Watkins?
No.
How about a Mr. Stevens or Angie Wright?
No.
How about a Patricia Appleberry?
No.
So, I want you to take a look at the binder in front of you, Mr. Walters. Before you open it, let me make sure I can help you pinpoint where we're going. I don't believe we have any objection on it.
No objection from Rural Water, Joel Odou, Your Honor.
No objection from AT&T.
Feel free to approach.
Thank
For him to show it to the witness.
you. Yeah, I'm not gonna put it on the screen, Your Honor.
Sure.
This is a part of the 290.
I understand that agreement by the parties, a certain document can be shown to a witness, correct?
Yes,
Joel Odou for Rural Water, that is correct.
Dan Boho for AT&T, yes, that's fine.
May I proceed, Your Honor?
Yes, you may.
So, just to kind of orientate you, Mr. Walters, I'm going to refer to the bottom right corner of the document. That's a bait number. This one says TH2385. I think the TH stands for Terrible Herbst.
Yes.
And this is a part of the 290 pages, okay? All right. So, this is an email from Anthony Randolph to you dated June 20th, 2016. So this is about 6 years forward of the last letter I showed you. You see that until that date? All right, perfect. And you understand that Mr. Randolph's email says Anthony@drinkrealwater.com, right?
Correct.
And in fact, the word real is also in the subject line. You see that?
Yes.
All right. When you did your search in November 2021, since you used the words real and water, shouldn't your search have picked up this document?
Yes,
And this document was an invitation from Anthony Randolph, Vice President of Distribution at Real Water, inviting Terribles to join in on an MMA promotional, correct?
correct.
All right, do you recall receiving this document?
I don't recall receiving it, but I've seen it now.
Right, and when you told Mr. Kemper that there were no communications, based upon this document, that statement to Mr. Kemper was incorrect, right?
There were no documents that came up in my email database search.
Sir, I didn't ask that question. So try to help me out in terms of focusing on the question. The question is, based upon this document sent to you by Mr. Randolph, there were communications between Terribles and Real Water, correct?
Yes,
And when you told Mr. Kemper that there was not, that was an incorrect statement, correct?
correct.
Thank you. Let me have you go to TH 2387. Yeah, are you there, sir?
Yes, sir.
All right. This is an email also from Anthony Randolph to you, correct?
Yes,
June 22nd, 2016, correct?
correct,
Again, this mentions the MMA. Is that correct?
correct.
And there, attached to it, this email, it says, attaches a proposal for Terrible Herbst partnership with Real MMA. See that?
Yes,
Now, looking at this document, the word real is in this document, correct?
correct.
The word water is in this document because it's in the email address for Anthony Randolph, correct?
Yes,
And in fact, the word real appears several times in this email, correct?
correct.
When you did your search in 2021, this document, as well as the promotional attached to it, should have been picked up, correct?
Correct.
Again, making your statement to Mr. Kemper an incorrect statement, right? Look at 2384, please. Tell me when you get there.
I am having,
This is another email. This is 3 years further in time, dated June 10th, 2019, correct?
correct,
Again, this is an email from Anthony Randolph to you, correct?
correct,
And in this case, the email has the word real and water separated, and it's talking about July and August promotionals. It says promo, correct?
correct.
Again, your email, your search in 2021 should have picked up all 3 or 4 of these documents at this point, correct?
Correct.
It says, hello, Mark, I need an email approval from you to provide to Ken authorizing the 2 for 3 promo that we discussed. See that?
Yes,
So you were giving authority on behalf, or being requested to give authority on behalf of Terribles to this promotional, correct?
correct.
And when you spoke to Mr. Kemper, you didn't recall this
No.
exchange? Roughly 2 years before you requested, you didn't remember any of these communications we discussed, correct?
Correct.
Did you know that Mr. Kemper was relying on your comments in responding to written discovery? Do you have an understanding what written discovery is?
Objection, Your Honor. Attorney-client privilege, with regard to a legal conclusion.
Of course, it was sustained, it was presented and sustained on the.
I'll change, John. And Mr. Walters, I don't believe I asked you anything about your attorney, so if I did, I apologize. You know, I'm staging the question to prevent any problem.
Okay.
The court will remind parties just in general that, and this is a general statement stated oftentimes to witnesses, when counsel asks questions, ask questions about communications with individuals and with counsels, and then parties, they feel that issue raises could raise an issue as to attorney-client privilege. Counsel, feel free to ask your question. With
Hey,
that caveat, it's assumed that the question is not asking about the conversation with counsel. If there's any issue, then any witness can just set forth that, other than counsel conversations, they can set forth testimony.
thank you, Your
It's a
Honor.
general statement, Brother Owen. Thank you so much.
Do you understand what the court just said, Mr. Wolf?
Yes,
Okay, perfect. And when I asked you the question, did you understand I was asking the conversation between you and Mr. Kemper?
I do now, yes.
Okay, well, I appreciate the objection. And I appreciate the court's sustaining the objection. I want to make it clear, I'm talking about you and Mr. Kemper, not you and any of the ET&T lawyers we have behind us, okay?
Okay.
Or the ones that may not be behind us, okay? Good. When you spoke to Mr. Kemper about communication, did you know that the information you were providing him was going to be used to respond to written discovery?
I didn't.
And when you gave him that information, you did so based upon your search within your own email and not within your department, correct?
Within my outlook, correct.
That's right. And did you, at that point, have any understanding of how long your emails were kept?
No.
Is this a good time for lunch break, counsel?
Uh,
Or you need another
I
moment?
just need one more moment, John. if I
Okay, no
could.
worries, that's fine.
Did you ever, when you responded to Mr. Kemper, sat down and think to yourself, because I'm assuming he's saying communications with real water. Did you ever tell him, I've had communications, oral communications, meetings, emotionals, all types of discussions with real water?
No.
I can stop there, you know.
Okay, perfect. Ladies and gentlemen, wonderful time for a lunch break, it being 12:10, so we're gonna ask you to come back at 1:25. So ladies and gentlemen, during this lunch recess, you are admonished not to talk or converse among yourselves or with anyone else on any subject in this trial. You must not read, watch, or listen to any report of or commentary on the trial or any person or entity connected with the trial by any medium of information, including without limitation, social media, text, tweets, newspapers, television, internet, radio, anything else not stated specifically is also included. Do not miss the scene and the events mentioned during the trial. Do not undertake any research, experimentation, or investigation. Do not do any posting or communications on any social networking sites or anywhere else. And do not do any independent research, including but not limited to internet searches. And ensure that you do not formally express any opinion on any subject after the case until it's fully and finally submitted to the time of jury deliberations. With that, we wish you a very nice lunch. Thank you so much.
All right.